Hello, and welcome to today's WJE webinar. My name is Liz Pimper, and I'll be your moderator for this webinar, Navigating the California Seismic Ordinances. During the next hour, WJE expert Conrad Paulson will discuss the implications of this ordinance and others like it, including the potential impact on real estate transactions, the legally required timeline versus a realistic timeline for implementation of a retrofit, and the importance of due diligence and staying ahead of the curve. This presentation is copyrighted by Wisjan Elsner Associates. And now I will turn it over to Conrad to get started. Conrad?
Yes, hello Liz and hello attendees. Thank you very much for coming by and joining us this afternoon. We would like to talk about the various seismic ordinances in California, and specifically we'll be looking at both North and South California. The learning objectives for today, we'd like to identify the general steps in the process to full ordinance compliance. Although the details of the ordinances that we're going to be talking about, you'll find out are different from ordinance to ordinance, the general aspect is the same. We'll look at the practical timeline versus the legally required compliance deadlines. There is a difference between the two. There's several types of buildings involved with the mandatory ordinances. We'll review that. And also we'll touch on some of the obligations an owner might have when selling a building that falls under the scope of these mandatory retrofit ordinances. So why are these various cities passing ordinances that require us to do something about the seismic worthiness of our buildings? The big thing is the older buildings don't perform very well. The most famous problems that occurred here in Southern California, on the left is the 1971 Sylmar earthquake and what that did to the Olive View Hospital. It was a brand new reinforced concrete building and was severely damaged in that earthquake. And then in the 1994 Northridge earthquake, there was the classic problems with the tuck under apartment buildings seen in the right here. These kinds of buildings caused the vast majority of the fatalities in the 1994 earthquake. So the governments have stepped up to primarily protect the lives of their residents. The bullet points here are out of this document called Resilience by Design, prepared by the City of Los Angeles. And it is their guiding document to look at increasing the resiliency of the City of Los Angeles to earthquakes. As mentioned, first and foremost is protecting persons and their lives. And the city is also looking at simply the ability of the city itself to respond to a catastrophic earthquake. And they want the city to recover quickly. It protects the economy of the city and also all of Southern California. The primary goal is to mitigate risk to life. It's not eliminating it, but reducing the likelihoods of injuries and fatalities in an earthquake. This is achieved through targeted mandatory ordinances. It's looking at only certain types of buildings and also is making sure that very particular defects or deficiencies in these buildings are addressed. So what do these ordinances not do? It's not the intent of these mandatory ordinances to ensure the usability or economic use of an individual building after an earthquake. Instead, these aspects are looked at in aggregate from the community's point of view, and these benefits accrue to the community as a whole. In other words, on the average, buildings are going to do better overall, but there is no assurance that any one individual building is going to do, be protected for continued use or economic losses. As a sidebar, there's nothing in the ordinances that prevent you from a retrofit design that brings you up to a higher level than what the ordinance requires. In other words, you may choose to do a more stringent retrofit that would allow you to continue to use the building after an earthquake or would protect you from these economic losses. And so the few takeaways here are in the help describe the context of a mandatory retrofit. First and foremost, they are there to protect the lives of people. There are regional benefits that accrue to the community overall from these retrofits that we will be implementing in the future. However, for individual buildings, necessarily following the retrofit requirements does not assure you of economic protection of that particular building. So an overview here of the various ordinances in California. It is frankly a patchwork quilt. There's so many categories and types of ordinances. We can't really describe in detail all of them, and so we'll give you this general overview here. Today we're going to focus on mandatory retrofits, but there's a class of voluntary retrofit ordinances out there that you may find useful, but we won't get into them in great detail today. And some of the so-called mandatory ordinances are reporting only ordinances. You need to tell the jurisdiction that, hey, I've looked at my building, it's a problem building, here's my report, and your obligation ends there. The jurisdiction is not forcing you to retrofit the ordinances. And we're not really going to talk about those either today. You just should be aware that they're out there. There's two broad categories: a new ordinance, specifically those that have come online perhaps since 2014 or 2015 through today, versus mature ordinances where the legally required compliance dates have long passed. We will very briefly overview them, but again, they are not a subject of today's ordinances. We're going to talk about the new mandatory ordinances, which typically cover one or a combination of 5 particular building types. And you need to keep in mind that the details of these ordinances are going to vary by jurisdiction. Here are the 5 target building types. The first one is called non-ductile concrete buildings, and that's illustrated by this photo on the right. A 1960s building that suffered damage in the Kumamoto earthquake in 2016. The columns are lost on the ground floor, rendering the whole building not usable. Others categories are the wood frame building with soft, weak, or open front walls. That's the classic tuck under apartment building from the Northridge earthquake. A new category that is getting mandatory attention is called pre-Northridge steel moment frames. There are only 2 locations that have addressed that right now, but you should be aware that there are mandatory requirements out there if you have a steel building also. The latter 2 bullet points are what we would call the mature ordinances: concrete tilt-up wall buildings and unreinforced masonry buildings. Those mandatory ordinances have been out there, frankly, for more than a decade or so, and the legally required compliance dates have long passed on those 2. So here in California, here's a listing of the jurisdictions that make up our patchwork quilt. For the wood frame structures, in Northern California, we have Oakland, San Francisco, Berkeley. In Southern California, LA, West Hollywood, Santa Monica, Beverly Hills, and Pasadena. For the concrete buildings, Los Angeles, West Hollywood, and Santa Monica have implemented mandatory ordinances. In Southern California, but not yet for Northern California. They are under consideration there. The steel frame buildings have mandatory ordinances in West Hollywood and Santa Monica, and it's under consideration in Northern California and San Francisco. Talk very quickly about the 2 mature ordinances here. What has happened as these other new ordinances have hit the streets, some jurisdictions have refreshed their old long-standing ordinances, and in particular, Santa Monica. They not only changed the ordinances, but they are going through renewed enforcement for tilt-up and unreinforced masonry buildings. Similarly, in Southern California, the jurisdiction of South Pasadena has become aware that several URM buildings were never brought to full compliance, and they've stepped up with new reinforcement in that jurisdiction. So how do you know if you have one of these buildings that are subject to the mandatory retrofit requirements? Sometimes the type of building is externally obvious, like the one shown in the photo here is a classic mid-century modern reinforced concrete structure. You can see the shear walls, you can very clearly see the concrete columns, and and the concrete floor slabs for the upper levels of this building. However, that's not always the case. Buildings clad in a modern curtain wall facade, you would never know what's inside the columns without literally digging into the building or getting access to the structural engineering drawings. In the end, you may need to seek assistance from a knowledgeable engineer or architect to determine the structural type for your building. Once you know that, then you can work with what the jurisdiction has on its books in terms of an ordinance. The jurisdiction typically sends out a formal notice called an order to comply or a notice to comply, depending on the vocabulary used by the particular jurisdiction. And then with that notice, the clock starts ticking for your legal obligation to satisfy milestones that are contained in the ordinances. Just as one example here, for completing the physical construction of a retrofit on one of the problematic concrete buildings, the City of Los Angeles allows 25 years to physically complete your construction. West Hollywood actually implemented a two-step process, 10 years to take care of the worst problems and 20 years to fully complete the retrofit. Santa Monica allows 10 years to fully complete the retrofit, and they've made that an intentionally short time frame because they feel within their jurisdiction they don't have that many concrete buildings to address. And then some jurisdictions, of course, have no mandatory requirement whatsoever. The message from this slide is the legally required timelines are simply all over the calendar, and you'll find the same thing with the other building types that I've mentioned. A few takeaways here. The jurisdiction initiates the legal process by sending out a notice to the building owner on record. That is sent in some form to the address on file with the county assessor and the name of the owner on file with the county assessor. If you wish to verify that your notice is accurate, or if you think you should have received a notice but didn't, here are the steps you want to take. You need to know the precise jurisdiction that your building is in. For example, in the western part of the LA metro region, you have the cities of Los Angeles, West Hollywood, Beverly Hills, and Santa Monica, all in close proximity to one of the other. Sometimes people are confused actually where their building is in that corner of LA. And so you do want to be very specific about where your building is located. And the main reason for that is the legal requirements will vary slightly from jurisdiction to jurisdiction. And the triggers for upgrade may also vary between them. WJE hosts a site called seismicordinances.com that can help you navigate through this process. The URL there is up at the screen. Very important, the S before the plural, before the .com. Be sure to include that. The applicable building types are listed here, and you can browse to your city of interest. We are in the middle of updating our website, and we'll be adding, for example, the steel frame buildings and some of the mature seismic ordinances in the near future. We hope to have that live in a week or so from now. With this section of the webinar, we're going to take a deep dive into some of the inner workings of one particular ordinance. And we're going to select the City of Los Angeles's non-ductile concrete ordinance. The main reason for doing this is the City of Los Angeles is the largest jurisdiction in California with mandatory seismic hazard reduction ordinances. They are casting a wide net. They have in their inventory over 13,000 wood frame buildings that need to be upgraded, and you'll see later on about 1,200 concrete buildings within the City of Los Angeles that are subject to these mandatory ordinances. Now, we're also looking at the NDC Los Angeles ordinance because these kind of buildings are typically commercial structures, and we're expecting that a lot of the folks attending on the line here today are somehow involved with the commercial building sector. You may be owners, you may be managers, you may be consultants who work for buildings of this nature, and it would be good for you to know what this is like. But in the end, the basic framework for all these ordinances are very much in parallel to the framework for the non-ductile concrete ordinance that we're about to review in detail here. So what does this buzzword non-ductile concrete, what does it mean? In other parts of the world, they're known as brittle buildings. An example of something in ordinary life that is non-ductile, take a plain old regular wooden pencil, try to flex it, and it will snap in half. That is a brittle behavior. And in the photo on the right, this is from the Olive View Hospital in the 1971 earthquake. The column at the left edge of that photo is a brittle column and has simply busted apart under the building movement caused by the earthquake. Now, an example at the other end of ductile, think of an ordinary metal paper clip. You can bend it back and forth several times. It'll distort, but it doesn't break. A very good description of brittle columns versus better columns was given in the Los Angeles Times. If you go online and dig up their Thursday, January 4 of last year, 2018, you'll find a front page article about the mandatory ordinances for concrete buildings in LA. And that article includes these illustrations shown here. They've done an excellent job with these illustrations. And this slide is probably the most structural engineering technical slide you'll see in this whole webinar today. But the illustration, if you compare the column on the left with the column on the right, you can see the column on the left has a sparse amount of reinforcing steel in it, whereas the column on the right has a lot more. It has a lot more vertical reinforcement and much more of these so-called ties. And it is the intensity of reinforcement in these columns that make them stronger and make them more ductile. Now, what other potential physical deficiencies might be out there in your concrete building? There are frankly too many to describe or even to prepare a shopping list in detail, but you could have problems with your shear walls in addition to problems with your columns. You could have problems with the foundations or beams or girders. Even the floor slabs could be a problematic issue with respect to earthquake loading. And so it's hard to prepare a detailed requirements in the ordinances to address these. And so instead, the ordinance requires that an engineering assessment be carried out according to national consensus standard assessment documents. For the LA non-ductile concrete ordinance in particular, what buildings fall under the net that the city is trying to cast? First of all, look at the original building permit application. Not necessarily when the building was being constructed, but when the paperwork and the structural engineering drawings were filed with the city for a building permit application. The date on that permit application is an important benchmark date. For the city of LA, if that was before specifically January 13, 1977, then your building may be subject to this ordinance. Now, what constitutes a concrete building? The ordinance, of course, provides a very specific definition. That's the subordinate bullet point in the middle of this slide. And if you'll bear with me, I'll read it verbatim. A concrete building is a building having concrete floors and or roofs, either with or without beams, supported by concrete walls and or concrete columns, and or concrete frames, with or without masonry infills, or any combination thereof. If you have the reaction that there's a lot of and/ors in there, and particularly that last clause or any combination thereof, yes, that's a very broad net they are casting, and the city is doing this by intention. There are a couple of exceptions, and it mostly involves, as shown here, detached single-family homes and detached residential duplexes. So, as we mentioned, the scope of LA's seismic ordinance is intentionally broad, and here's an example of what happens. This is a single-story commercial structure located within the jurisdiction of the city of Los Angeles. Its seismic resisting system is the concrete block shear walls you see here in this photo. However, the structure has parking up on the roof, so there's a concrete roof slab. In the back of the building where you see that, this is a concrete building version of a tuck under parking. You can see the concrete beams and columns that support the concrete roof slab. And despite the fact that at the interior of the building where the retail occupants are at, it's steel columns supporting the roof. And so despite that, there is enough concrete in this building that it falls under the scope of the ordinance. And so an important thing is these mixed material buildings. We have concrete block, we have steel columns. Those are enough concrete in these kinds of structures that they fall under the scope of the ordinance. So what constitutes compliance in LA? We're going to talk an awful lot about trying to achieve conformance to the ordinance by retrofitting, which is the fourth bullet point here on this list, but there are other ways of getting to the end point of compliance. Probably the first two actually are if the buildings have been previously retrofitted. There are two different types of engineering criteria to assess whether your retrofit qualifies, but if you have done the work already of a retrofit, there's a good chance that you can demonstrate conformance without doing further work. There's also a opportunity given by the ordinance to run a detailed engineering analysis of the building as it is, and if you can successfully demonstrate it complies with the engineering requirements of the ordinance, you do not have to do an upgrade. Frankly, the older your building is, the less likely you're going to satisfy an engineering analysis by itself. And that's because with time, the codes have changed. And the further back you go, if your building was designed under a really old building code, it's not going to have the strong columns that you saw illustrated by the LA Times article. A fifth option that's out there is demolition of the building. But overall, it seems the most likely path to conformance in LA will be to retrofit the existing building. So what is LA's legal timeline or milestones that you need to achieve? This shown here is called an order to comply. And on the face of the order, on the face of the order in the lower right-hand corner, you'll see there are three items: a checklist, plan submittal, and work completion with deadlines in years. Those are the legal milestones you need to achieve. And these legal milestones are shown here graphically. The clock starts to run when the order to comply is issued. You have 3 years from the order to comply to complete what we'll describe later on as the NDC checklist. You have 10 years to get to submitting your retrofit plan and the supporting structural calculation package. And you have 25 years to complete the work. One important thing to notice is that these timelines, each one is individually absolute. They are not cumulative. They run in parallel, as is shown in this graphic. Now, a few other things you might want to keep in mind about the ordinance. This is all public information. It is recorded with the office once a building is served with an order to comply. So you can go down to the county assessor's office or go on to their online database and find out whether a building has been cited. And that's not just for LA jurisdiction, but almost every jurisdiction that has a mandatory ordinance is doing this kind of thing. If you don't receive the ordinance, whether the ordinance proverbially, or if you don't receive your order to comply, for example, it got lost in the mail, or maybe the city didn't recognize your building as a concrete building, and so the city did not send you an order to comply, well, those do not relieve you of the legal obligation. You still need to satisfy the requirements of the ordinance. The ordinance specifically states that if you change ownership, the obligation transfers to the new owner and the compliance dates do not change. In other words, the clock has started ticking and there is no reset button for that ticking clock. The ordinance also includes an obligation to notify the tenants and occupants that the building has received this order to comply. I'd suggest that you dig into the details of the ordinance to see what that obligation is all about and what constitutes satisfying that obligation. Footnote for residential buildings, you may need to do a different form of notification to your residential tenants, and you might have to prepare what the ordinance calls a tenant habitability plan. Again, refer to the wording of the ordinance itself for further details. This is the obligatory slide I have with too much information on it, but I will try to give some navigation assistance here. The first 6 line items above that heavy solid bar, the horizontal line near the middle, they are all the ordinances that mandate wood frame buildings be upgraded. The important thing to notice, they all have a very similar and very short timeline to full compliance. At most, you have 7 years to comply and fully complete the mandatory retrofits of these wood frame buildings. Now, why such a short fuse? These are residential buildings and people live there. And so this is where the ordinance or the jurisdictions see a big impact in a short time for protecting their citizens. And so all of these have the short time frames. Some are as short as 4 years to compliant, depending on jurisdiction and the size of your apartment building. The other thing of note is Northern California was ahead of the curve on this one as compared to Southern California. A couple of the Northern California mandatory upgrade ordinances are in fact approaching their maturity, and all of the buildings in the jurisdiction that are wood framed will need to be in compliance within the next year or two. At the bottom are the typically larger buildings that will be multi-story commercial structures, concrete buildings, and steel frame buildings. The jurisdictions typically give a longer timeline than these wood frame residential structures. For example, the concrete buildings from as little as 10 years in Santa Monica to as much as 25 years in the city of Los Angeles. The steel frame buildings are in a similar situation. The jurisdiction of West Hollywood has a unique feature. They have staggered, in a single building, in fact, they have staggered compliance dates. They are trying to get you to address the worst of the worst seismic engineering problems first, and you have 10 years to address the worst deficiencies. And then the lesser deficiencies, they'll give you up to 20 years to physically address. So the takeaways on this, the scope of the City of Los Angeles Non-Ductile Concrete Ordinance is intentionally broad, and you'll find that same feature in ordinances from other jurisdictions. And again, regardless of jurisdiction, if you didn't receive or the jurisdiction does not serve the order to comply, the legal obligation to retrofit still exists. The fact that a building has received an order to comply is a matter of public record, is transfers to the owner when the property changes ownership. And then in the end, the timeline to achieve legal milestones, for example, 10 years to do plans and 25 years to finish construction, that seems ample. However, from a practical point of view, that timeline may be short. And again, as this next section here will look in detail at the practical aspects of achieving these milestones. And again, we will use the City of LA's Non-Ductile Concrete Ordinance, for example. So what is the difference between what I've nicknamed the legal milestone dates versus the practical? Well, the legal is established by the wording of the ordinance. It is like thou shalt submit your screening report within 3 years, and you need to have the retrofit plans and a building permit application in hand by 10 years. The practical is the necessary calendar time that needs to happen in advance of these milestones to develop the submittals to satisfy the legal requirement. Now, here in LA, for this particular ordinance, keep in mind, 2 years have already passed. Most orders to comply were issued in November and December 2 years ago. And so the years you see here, the times indicated here have been adjusted to reflect what is actually left of these milestones. The NDC checklist, for example, the city has given you 3 years. 2 years are already consumed. You only have 1 year left to file that report with the city. Retrofit plan and building permit, only 8 years left. And to physically complete your retrofit, 23 years. And so the message here is the clock is ticking already. So the first milestone, what is that? What is this NDC checklist? It is a city-provided form, and it is a screening or information gathering form primarily, but it does get into some particular engineering issues. You will need an engineer licensed in the state of California to complete this for you. From an engineering point of view, this is a fairly straightforward document. If the original structural engineering construction drawings are available. If not, it could be problematic trying to gather some of the information requested by this document. And so how do we get to the end point of this seemingly simple first task milestone? First of all, try to see if you have the original structural drawings for the building. If yes, it's probably 2 calendar months to get it done. 1 month for your internal procurement processes. You know that process better than I do. This 1 month is based on experience, and the fastest I've successfully gotten one of these checklist projects in order with our clients. And the 1 month is not unreasonable. Depending on your internal decision-making process, it could actually be longer than that. Once you've sent out authorization to your consultant, the consultant is most prudent. They have a brief engineering site visit just to verify that the available structural drawings are reasonably accurate, and then you need to complete the checklist and you need to physically get that checklist to the city. That would be another month, 2 months cumulative total for that process. So what if the original drawings are not available? The field aspects to gather the information requested by the checklist is the wild card there with that process. And I would say allow the engineer about 2 months to complete that if you do not have structural engineering drawings for your building. So where are things at overall with this process? The graphic you see here is prepared by the City of Los Angeles Department of Building and Safety. It's publicly available on their website, and they update it on a monthly basis. This is the most recent graphic issued on October 1 of this month. The very first bar there, that gray bar, is the number of orders to comply that the city has sent out to concrete building owners in Los Angeles. They sent out about 1,400 orders to comply. To date, they've identified, the next bar column here, the yellow one, they've identified that 154 of these buildings may have been previously retrofit or are exempted from the ordinance for various reasons. That leaves approximately 1,200 buildings that have to run the process of full compliance by retrofit or by demolition. Of that number, the folks who have completed the checklist is shown in the third bar chart. And this is the checklist project at year 2 of 3 years. A total of 81 buildings out of the 1,200 buildings have submitted checklists to date. Now, if this checklist completion process were linear with calendar time, that number should be about 800 buildings, not 81 buildings. So what's the message here? The procrastinators are winning. There's going to be a logjam a year from now to achieve this compliance if folks don't realize what's going on here. So the takeaways, don't join the field of procrastinators. You want to be on the good side of the city in this process. The checklist is actually a straightforward engineering assignment, but still you can't procrastinate. You probably have to identify an engineer to do it, then you have to get them under contract, and then you have to allow them enough calendar time to get the work done and the paperwork into the city before the compliance date passes for the first milestone. We're also recommending here that you combine this straightforward first task with some of the first steps towards achieving the 10-year milestone, and we'll discuss that in the next section of this presentation. So what is this 10-year milestone? Typically, it's submitting the retrofit plans, including getting the retrofit plans and supporting structural calculations through the permit review process and getting your permit in hand. These bullet points are all nitty-gritty engineering stuff. It will most likely be performed by an outside consultant you retain. And most of these bullet points are steps along the path required by the ordinance. There is an additional recommended bullet point in there, and it's the fourth one down. It's called Develop Conceptual Approaches to Retrofit and Pricing. And this step is recommended by us for you to develop some firm information about what are you going to physically do to the building and how much is it going to cost. The rules of thumb out there that people have been quoting in terms of dollars per square foot of floor plate and that kind of thing, they are proving to be wildly inaccurate. And they're wildly inaccurate in both directions. They understate costs and they overstate costs depending on the nature of your building. And why is that? It's because each building to be addressed under this ordinance is very unique, and each one needs its own custom approach to retrofitting. And so a simple rule of thumb does not exist. There is no such thing as one size fits all with repairing a concrete building. Other considerations here, depending on the nature of the structural engineering aspects of this seismic retrofit, you might want to do some of the other items mentioned here. For example, add in cost estimating at conceptual design, so you have a rational basis for making your business decisions going forward. And that can happen fairly early in this 10-year process. You might want to undertake some other improvements at the same time. You know, maybe the elevators need updating, or new ventilation systems and air conditioning, that kind of thing. Maybe you want to take the retrofit construction as a phased approach. And so that phasing needs to be shown on the documents that are sent out for permitting. And what about financing of the construction? That's in your folks' bailiwick, and you know the timelines involved with that much better than I do. And then in the end, if you have a residential structure, you'll have to deal with tenant notifications and a habitability plan. Each of these adds a length of time to this milestone. Now, what about the overall practical timeline for this kind of thing? You already heard me say there's no one size fits all and no rule of thumb for prices. The same thing applies to the duration for achieving this milestone. In the end, this will most likely be a multi-year process, even for small buildings. So the main takeaway here for the 10-year milestone is get going right now. There's only 1 year left to complete the Los Angeles NDC checklist, and there's only 8 years left to achieve the 10-year milestone. And you can do both at once. Complete the checklist and take these first initial modest efforts towards the 10-year milestone right away. And these modest efforts will likely pay off in the long run because you'll get a rational estimate of both cost and timeline from these concept designs and the construction pricing of the construction designs. And that information will allow you to go forward for the rest of the 10-year plan and for the 25-year construction milestone to proceed in a rational fashion. So what about this 25-year milestone? Well, it's physically constructing the retrofit. You need to have the retrofit fully done and your updated certificate of occupancy in hand, in other words, the full compliance certificate by the end of this 25-year milestone. Frankly, it'll be driven by the complexity of the project and the construction duration for that. If you have a larger building, or if you're going to undertake, for example, a whole building renovation at the same time, it'll be a multi-year process. But you should probably proceed, once you get permit in hand, proceed into construction in an orderly fashion, because you'll want to beat construction cost inflation. For the 25-year milestone, that's about all we'll have to say today. It indeed does seem like an ample timeline has been permitted, and we'll perhaps return to a future webinar to talk about this in more detail. I'd like to wrap up with a few closing comments here. Regarding the effect of these ordinances on property transactions, keep in mind, the order to comply is typically publicly available information with the county recorder. On the left hand here, you see a graphic that shows a bunch of building outlines that are color coded. This is a snapshot off of the City of Santa Monica's website. They have made it publicly available in graphic information system, GIS, to show that what buildings in the city are affected and how you might address those. As we mentioned before, the order to comply transfers with the ownership. It persists with the original timelines that started when the order to comply was issued back 2 years ago. And you could find it of benefit in the long run to know at least order of magnitude costs, rough costs, but rationally developed, that will help you wrap your head around how much these retrofits will cost. And in the end, talk to the other folks in your professional network to see what their experiences are. There are some property transfers that have happened already to buildings that have received the orders to comply. One of my clients told me frankly that the order to comply had absolutely no effect whatsoever on the real estate transaction. Other clients have reported otherwise. Overall, the ordinances are indeed a patchwork quilt, and you need to find where your patch is in that quilt. You need to know the jurisdiction and their ordinances, and you need to know your building. With that information, you can figure out whether your building falls under a mandatory ordinance. In any event, you most likely have already received or may be about to receive from the jurisdiction a legal notice to comply with the mandatory ordinance. If your building does fall under the ordinances, it's prudent to take action right now. Everything is shaping up that there will be a logjam at even the most simple step to compliance, completing these checklists. And then keep in mind, for all of the ordinances talked about today, the clock is ticking for the vast majority of them right now. And so do take action and start with the very basics. So this is the overall information we wish to convey to you. I thank you for your attention, and we will open it up with a question and answer period right now.
Thank you, Conrad. As a reminder, if you have a question, please type it into the Q&A box rather than the chat box. Please type in questions into the Q&A box and hit send. And if we don't get to your question during the call, we will follow up with you afterward. Conrad, do you want to take our first question?
Sure. I have a question here. I don't see any mandatory ordinances for concrete buildings or steel frame buildings in Northern California. Are there any under consideration? Yes, there are. In particular, the city of San Francisco is considering both. They have been discussing concrete building ordinances for some time, but no ordinance is enacted. In the past month or so, San Francisco has also added discussion regarding a steel moment frame buildings and a mandatory ordinance for them. Just again as an aside, the Bay Area was ahead of the curve with mandatory wood frame retrofit ordinances. and a couple of those are reaching maturity, as we mentioned before. But with steel and concrete frame buildings, the Los Angeles region is ahead of the curve on that. We also occasionally get asked, what about Orange County and San Diego? There are some rumblings of discussion in those two areas of Southern California, but no ordinance has yet been passed to our knowledge. What about, let's see, we'll look at some of the other questions here. In terms of, one question evolves around what actions perhaps could tenants take? And that is a difficult one to answer because you need to know about the building. We very often get asked, is my building under the scope of this ordinance? And you can find that out by going off to the city you live in, look at their website, and see what they may be requiring. Another question we have here is, in the city of LA, construction permits are only active for 18 months. After that, you have to go back through plan check. Yes, that is correct. And these will be subjected to the same requirement. There's nothing stopping you from, letting the 18 months lapse and reapply. If you don't want to immediately start construction upon getting your permit, that's a possible, business strategy you could use. Another question that has come through, this is a significant question and may is a little bit time consuming, but it's a big deal. Suppose I miss the deadline for submitting a checklist or screening report. What are the consequences? And it's frankly a bit of a loaded question. And as you can imagine, the answer is going to vary a little bit by jurisdiction. But looking at what's happened across both Northern and Southern California, there's a lot of parallels. We've actually been asked this question before, and we've looked into it. Here's a few standard features regarding enforcement, shall we say, for these ordinances. First of all, if your work is proceeding in compliance with the ordinance stated milestones, there is no violation. Typically, if you have documented progress on file with the jurisdiction, they give you an exemption and will not issue a violation. And these exemptions happen at each step in the way. If you've already satisfied, for example, the 3-year milestone, you're good to go. And the next milestone of legal concern would be, for example, the 10-year plan submittal milestone. Now, what happens if you do slip into violation? Well, one ordinance says it shall be unlawful for any person to use, own, or occupy or maintain any building that does not conform to the requirements of the ordinance. For that clause, who is held responsible? To quote verbatim from another one of these ordinances, any person includes an owner, lessor, sublessor, manager, or person in control of a building subject to this ordinance, unquote. However, all of these ordinances typically exempt tenants or exclude tenants from being the subject of enforcement. In other words, it's the persons in control or the entities in control of the property, not the tenants of the property who are subject to enforcement violations. And what's the consequence or penalty? Again, it's best to relay this as being verbatim from an ordinance. And one ordinance says, any person who violates or causes or permits another person to violate this ordinance is guilty of a misdemeanor and shall be subject to prosecution and or administrative enforcement. Then some jurisdictions add a further clause, quote, each such person shall be guilty of a separate offense for each and every day or portion thereof during which any violation is committed or continues, unquote. And so in the end here, the jurisdictions are very serious about these ordinances. If you find yourself in violation, consult your attorney and also consult the applicable ordinance to see what your obligations are. Another question that we have, are there any mandatory ordinances under consideration in Seattle or Portland? I believe one of the two cities has been talking about that, but I don't know that anything has been implemented. As we work further on our website, we're going to reach up further into the West Coast. Washington state would be the next likely area for these ordinances to crop up and be enforceable. We will further research this specific question and get back to the questioner offline in the future. And with that, Liz, I think we've come to the end of the line of both our presentation and the series of questions that we've received from folks. Liz,
Okay.
you have your closing comments, please.
Yeah, thank you, Conrad. So that does look like that's all the questions we have submitted during the webinar today. As a reminder, if you have any other questions, we will send out a follow-up email that will include Conrad's contact information. So feel free to reach out to him with any questions that you think of in the meantime. That email will also include a link to a recording of today's webinar for you to reference later and share with your colleagues. And that email will also include a link for you to request AIA credit for your participation in today's webinar. So we really like to thank you for joining us. Thank you, Conrad, for the presentation. We appreciate your time and we hope you have a great rest of the day.